Good afternoon, folks. Welcome to the BEARDS Talking Business. The death, so stand by your beds. Usual suspects, myself, Chris from Ajax Wealth, Mark Maclean from Straight Line Law and Straight Line Legals, and special guest, Raf Singer. Is it Lion's Head Law, Raf? Is that right?
Yeah.
Private client solicitor who is an expert on IHT, wills, probate, etc., etc. So that's what we're going to talk about today. I bet you can scarce contain your excitement. So, but we're going to throw it to Raf to let him get his intro in, so we all know who he is, and then we'll get right into the questions. I've got a few pre-submitted, but as always, we want your live questions as well. So fire away, Raf.
Okay, so yeah, Raf Singer, private client solicitor. So that means I deal with wills and probates, trusts, powers of attorney, inheritance tax planning. So I'm a self-employed consultant under Lion's Head Law, which is a small firm, and all of the solicitors there are self-employed consultants. I'm the only private client solicitor there. I've been qualified 10 years now. I actually started off in family, which was ridiculously stressful because divorce and children are stressful, whereas death isn't really that stressful, especially when it's non-contested. I am step qualified solicitor, so that means
hard to contest, is it not?
What's that?
Death's quite difficult to contest, I would have thought.
There's various ways you can contest it, but when check the pulse. But when people are fighting over an estate or a will, I send that down there. I don't do any litigation work. But yeah, so I've got the STEP diploma, which is the Society of Trust and Estate Practitioners diploma, which is deemed the gold standard qualification in my profession, and it's really good to put those letters after my name, TEP, because then someone like Chris looks at me on LinkedIn and he's like, all right, that guy, he's clearly of a certain standard. So and that's me. That's what I do.
Good stuff. Excellent. So we've got a few questions, but before we go, Mark, the other solicitor in the room, always likes to get his disclaimer up so that everybody realises it's no advice that we're giving here. We're just chatting amongst friends. So go for it, Mark.
Okay, I'll just share my screen. Give me 2 seconds. Hopefully that works, but Alan, you might have to prove it. Has it come up yet?
Yep.
There you go. One day we'll find a way of just making this really slick. Clearly one day is not yet here.
There must be a button you can press and it just pops up, but we haven't figured that out yet. So there we go. That's probably enough of that.
Yeah. Is that you, Mark?
Is there a cat somewhere?
Yeah, sorry, there's a cat, and it's either trying to get in the room or trying to get out. So one or the other.
Fair enough. But if it's got any questions, tell it to just pop them in the comments.
Right, we'll answer any questions that the cat may have. Right, so we've got a few pre-submitted questions. Raphael, you're probably going to get hit with them all at the moment. As I said, although I work in tax, IHT ain't my thing. Chris and Mark have probably got more information and more knowledge about IHT than I have, to my shame. So I might augment the questions with questions for myself, but we'll see how we get on anyway. First question from John Cox, I believe is a client of Chris's. Quite a simple one here, I think. What is the limit before inheritance tax kicks in?
So simple question on paper, but can be quite complicated. There's three main points to think about when inheritance tax kicks in, and that's marriage, children, and property. So on the face of it, everyone has something called the nil rate band, which is £325,000. that nil rate band, then that means the first £325,000 is taxed at 0%. Okay, so it's still got a tax rate, but it's 0%. And everything above that is taxed at 40%. So that's £325,000. That can be on death. Okay, and if you do any wild gifting in the 7 years before death, then that will reduce this nil rate band of £325,000. But let's say that's not been done. There's been no gifting. So you've got £325,000. Now, if you're married and you've got children, you've got property, then those other factors come into play. So let's say you've got children and property, you've also got an extra band called the residence nil rate band, and that's worth £175,000. So if you've got those, you've got children and property, then you've got £500,000. Now, if you die leaving everything to your spouse or civil partner, that's not only spousal exempt, so any amount that you leave to your spouse or civil partner, from 50 quid to £3 million, all exempt. Okay, if that all goes to the partner, they can use those unused nil rate band and resident nil rate band. So they've got their own £325,000, their own £175,000, and then they're using the nil rate band and the residence nil rate band from their deceased spouse or civil partner. And that means they've got on their estate £1 million taxed at 0%. So if you've got a nuclear family, you're married with kids and property, and on the first death, everything goes to the spouse. And then on the second death, everything goes to the children, or at least the property goes to the children. Then you've got £1 million until inheritance tax kicks in. But if you're a very lonely man or woman, and you're not married, you don't have kids, you don't have property, all you've got to play with is £325,000. So it all depends on your circumstances.
Right. Okay. So fine. So that makes sense. So with a little bit of planning, or not even too much planning, really.
You don't. This is the thing. You don't. Yeah. So to use £1 million in a typical family, you don't need any planning apart from a will, and that will stating that everything goes to the spouse on the first death. Right. That is the only planning you need. If your children, and it doesn't matter what age children in terms of what I just explained before, if your children are over 18 on that first death and there's no will in place, you can vary that will so that you can vary the intestacy. If there's an intestacy and no will, you can vary it so that everything goes to the spouse and you can make use of all those tax bands. If the children are under 18, you can't vary it without the court's permission. And if you go to the court saying, I want to vary this intestacy because otherwise there's going to be tax to pay, the court's going to say, no, because we want to guarantee that the children are going to inherit. So that's a lot of words, but really in terms of tax planning to make use of the second spouse to die with £1 million taxed at 0%, the only tax planning you need to have is a basic will.
Okay. So
and that intestacy that Raf mentioned there, just in case you've not come across that term, that just means if you die but you haven't made any sort of will. Intestacy is basically the government's rules as to who gets what if you're not here.
Yeah, so there's very specific rules about how an estate is distributed if you don't have a will. And if you've got a spouse or civil partner and no children, then everything goes to the spouse. It's great. But if you've got children, then it gets really complicated. The spouse gets a big chunk. Everything left over is divided into two. The spouse gets half and the children get half. And it can get very messy if it's a large enough estate where inheritance tax will kick in, unneeded or unwanted trusts will kick in. So those intestacy rules are there to make sure that people in the family will inherit. It's like a government, absolute default. But yeah, like we were saying, the most simple inheritance tax planning is getting married and making a will. That's it.
Yeah, and if obviously, as you said before, if the plan is that everything is to go to your spouse, then what you're saying is absolutely, definitely make a will to reflect that, because if you don't and you have children, it won't all go to your spouse. And then the threshold point kicks in, doesn't it?
Yeah, and to vary an intestacy or vary a will, the people who stand to lose under that variation have to consent to it. I mean, that common sense, and that's why children under 18, they don't have capacity to be able to do that. So, you know, all lovely if the family gets on, all lovely if the children are adult, and then you can tinker things after the death. But if not, you're really playing with fire. And how many families are there where there's tension? You know.
Right. So here's a genuinely hypothetical question, a hypothetical situation then. 51-year-old, 52-year-old man, probably with a estate value, including his businesses and stuff, maybe about 1.5 million. He's got 3 kids aged 26, 22 and 17, and he's not got a will. What does he need to be doing?
Well, I'm assuming this is under
Obviously,
the jurisdiction of England and Wales.
Let's say no.
Because I can't advise on any other jurisdictions, for instance, Scotland. But under England and Wales, yeah, you just get married. Get married.
Oh, sorry, the guy is married.
Yeah. So if they're already married, that's really useful. The very slight issue there is that this, you know, if you wanted to vary it, the 17-year-old wouldn't be able to consent to that. So just make that will. So, you know, I'm obviously going to sell myself, sell, you know, what I have to offer, but you can do anything. You know, you can go to a will writer, pay a couple of £100, take your chances. Less regulated, maybe less qualified, all the way up to, you know, going to the city, spend 2.5 grand on a basic will. You know, there's all these kind of steps. But what I would always advise is you do get it done by a solicitor, because why not? It could be the most important document you ever draw up and sign. And, you know, get a step qualified solicitor, get someone who's done the gold standard qualification, the benchmark qualification that's worldwide. And I say that to people not because I necessarily want the work. It's just go to someone else. If you don't like my face, go and see another solicitor who's still qualified. It's just, it's a big, you know, people put off making a will. It's a big decision. It's a big psychological decision. It always gets lower and lower down the to-do list. Oh yeah, I know I need to go around, get that will done. But get it done, get someone professional, and you'll just sleep better at night.
Now, this hypothetical person that we're talking about here has been putting off getting a will in place for probably a decade. And it's milestones in this hypothetical person's life where you think, well, we need to start thinking about this, but it's a bit of kind of depressing and morbid thing, you know.
I mean,
and I think he probably has a wee bit of a theory that he might be immortal as well, you know. So.
You never know. There can be only one, I think. But,
very good.
Yeah, but the best time to make a will is yesterday. The second best time is today. You just, I have the most morbid conversations with clients because that's my job. I have clients sitting in front of me and I'm like, okay, so, you know, obviously you want to give it to each other. You know, your children that you love. Imagine one of them's died. And, you know, I go into that kind of detail. It's not a nice process, but you will feel better once you've done it. And you know you've got to do it.
I know.
I think your hypothetical.
Say again, Chris.
So I was just going to say, I think that your hypothetical chap, whilst it is a morbid discussion to avoid, the thought of leaving an absolute shitstorm behind him for everyone to tidy up, where, you know, if there's no will, if stuff's getting left to the kids, and the other half, you know, it all should really be going to your wife or the hypothetical man's wife, and then you've got to go and get everyone to sign stuff, change stuff, move it all around. And when they've just lost this fella that sounds like a hero among men, the last thing that they want to be doing is, you know, tidying up all this mess. It's worth a few £100, surely.
I had I can't remember who I was speaking to. It wasn't a client. It was maybe someone in a networking group. And they said, oh, I've got this friend of mine, and what's putting her off making a will is doing the guardianship clause. She can't stand the idea of appointing other people to look after her children, even though she knows it's the right thing. And she says, how would you deal with that kind of person? And I said, when they're ready, they come to me. I'm not sitting there trying to convince everyone around the world to make a will. Okay, on an individual basis, because that would literally be all my time spent. People need, once they're ready to make it, they go and see the solicitor. But until then, you know, they know, everyone knows they need to make it. It's just the psychology of it is very hard for some people, not for everyone, but it really touches a nerve on some people. And I post about it on LinkedIn. I want to talk more about the psychology of it, because the longer I've been in doing this kind of work, the more I feel that's much more important than the law.
Yeah,
which is all similar to a lot of your work too, I guess, Chris, and everyone else, really.
Yeah. A lot of it is talking around the law and trying to get people comfortable with things like risk and you know, in your case, death. And I think there is a natural inclination to just want to bury your head in the sand and go, that's not going to happen.
Yeah,
not going to happen. I don't need to worry about that yet. I'm young, and you know, from my perspective, it was an interesting. I mean, we've made wills. I made them a few years back, but the trigger for that is my you know, you think, well, it was 50, 60, 70, whatever it is, but my mum died at 45 and my brother died at 48. And that's like, you know, they're young. That's young in the scheme of things. And so you start thinking, Jesus, you know, it's you literally never know. And you know, get it done as soon as possible, I suppose, is
unfortunately. Yeah, unfortunately, the best clients are ones who have been touched, you know, with difficulties in their lives. So a lot of my work is also, when I'm doing wills, I always advise on lasting powers of attorney. In Scotland, there's a very similar equivalent. And, you know, death is definite. Okay. So lasting powers of attorney are where you're able to appoint your loved ones, or in certain cases, professionals, to be able to make and take decisions on your behalf should you lose mental capacity. Now, are you definitely going to lose mental capacity? Don't know. Who knows? Are you definitely going to die? Yes. You know, I advise people to make both, make it all. And people associate, again, lasting powers of attorney or those kind of questions again with old age. You know, why? But it's the same thing as you know, insurance brokers have similar, you know, conversations. It's like, you know, it's like making a bet, isn't it? But wills, you know, it's great to an extent that wills are quite unregulated. You know, that's a kind of good thing. Access to justice, low fees. But, you know, once you start going down the low fees route and a race to the bottom, and people who aren't, you know, so qualified or so experienced, you've got to remember this is one of the most important documents you're going to be making. And so many clients, in fact, almost all clients, when they come to me, they say, oh yeah, my affairs are pretty straightforward. But literally almost all clients say that to me. And most of the time they are, you know, but they don't know what makes their situation slightly different, where you can add a little bit of value, a little bit of a tweak. And, you know, that's where I come in.
I saw a solicitor
wills
charging £57 for a will.
£57. I mean, it's like putting your life in the hands of £57.
Qualified solicitor with a home visit, apparently. I'd just beyond me how that's managed. I think it's a bit better also, if you ask me. Like,
one thing I ranted on LinkedIn was about solicitors who use wills as a loss leader to then get the probates, and often they'll magically be named as one of the executors, so they're tied in.
It's a big thing as well. This happens a lot, doesn't it?
It does, and I got, as you saw, Mark, I got pushed back on that.
You got. Yeah, that was a bit of a controversial. That was a hot one, wasn't it, on LinkedIn? I think when you find that out there.
Well, it's great that you knew the person who was ranting about me, but
small world.
So there is benefit to solicitors being appointed as executors, in the right circumstance. If family doesn't get on, if their affairs are complicated, if trust is definitely going to arise. But you've got
to have that conversation, haven't you? You've got to have that conversation and say, do you want me to be involved in this, or would you prefer to manage it? And some clients, I imagine, will say, do you know what, you take it all. We don't, don't want to. We can't be bothered with this. We don't want to be messing with this. But it's about having that conversation and being really upfront.
But and a step back, just going back to Alan's point about these cheap wills, you've got to ask. It's literally using wills as like a marketing. You want to really be instructing someone who's going to be charging fairly on a will, fairly to both parties, and fairly on the probate, and not using one to bring them in and then fleece them on the probate.
I think there's not many things you'll buy in your life that you'll never know if they were a piece of crap or not, and a will's one of them.
Yeah, that's a really good point.
Yeah.
So, get your questions in, guys. We've got an expert here. We really should be using them. So, going back to my hypothetical situation, just one quick question I want to clarify. I know you mentioned you can only advise on England and Wales, but substantively, Scotland's more or less the same. There's not an awful lot of difference in the. This isn't the advice, by the way, Raf, as we've already said.
I guess probably it's not so much me not wanting to get tied in. It's more the fact that I don't have that much experience of it. So I think
Raf's already picked up on the subtitle of the LinkedIn Live that we were nearly called "It Depends." So he's nailed it. Right. So back to the 1.5 million hypothetical. So the will's in place and the spousal transfer or what have you. So that takes care of the first million, right? I mean, that's fine. So there's not been any tax planning done, and we're still in good nick. But we've now got the next tranche, the next portion of inheritance or value or estate, 500 grand. Without any planning or without anything having been done, that's going to be 200 grand. That's going to get
So that's right. So
this is what we need to talk about. How do we make that better?
So how inheritance tax works in England and Wales is that inheritance tax that arises on property and some kinds of shares can be paid in 10 yearly installments. So that ensures that there's no immediate tax due on a property that's not been sold. Okay, so that £500,000 will then be, and then the first instalment is due 6 months after the month end of the date of death. So if the date of death was like the 15th of January, then you're looking at 6 months after the end of January. And then interest starts to accrue. Interest currently is the same, I think, interest for HMRC across the board. So that's 7.75% at the moment. Lovely. And then inheritance tax that arises on all the other assets are due on that 6 month date. So on that 6 months after the month end of the date of death, you've got the first instalment due of the property inheritance tax, and then all the rest of the inheritance tax due on everything else. So those are the kind of things you might want to be thinking about. In terms of planning, I mean, there's loads of things you could do.
Before we jump into that, could I just ask a question that I think is quite pertinent to this hypothetical scenario? If I remember rightly, Alan, this hypothetical chap had a business, didn't he?
Aye.
How much of that 1.5 million was related to business value?
I would say about half it.
Okay.
Yeah. So so what Chris is alluding to there is that, and that's all owned as a limited company.
Yeah.
Of interest.
Hypothetically.
Hypothetical limited company. So those kind of assets would qualify for something called business relief. Used to be called business property relief. It's now called business relief. And in that kind of circumstance, that would be taxed at 0%, as long as it's been held for 2 years. And if it passes to the spouse, then the time frame of 2 years takes into account how long the first owner had it to. So if the first owner just happened to have that for only a year, and then the surviving spouse only had it for a year when it passed to them, that 2 years would be satisfied. So it could be, Chris is absolutely right. It could end up being that there would be no tax on the estate because of that.
Then the discussion naturally then goes down, well, is your this hypothetical person's wife going to be running that business? Is she going to keep a hold of it until she's no longer here?
You wouldn't necessarily, if you didn't want to, you wouldn't necessarily need to leave that to the wife if you didn't want to, because you wouldn't need to rely on the spousal exemption for that.
Right. Okay. So fine, that makes sense. So in that particular hypothetical situation, the spouse is actually a shareholder in the company.
So that would reduce the value of the business on the first death, then, wouldn't it? Or the estate on the first death.
But that 750 value is the hypothetical dead person's share. So the business is valued roughly.
Oh, I see. You've already taken that into account.
Aye. So the business is roughly valued at £1 million. The hypothetical guy has got 75%. The hypothetical guy's wife's got 25%.
Okay.
So taking aside the tax situation, when that guy dies, he's got life insurance, and I believe that it's it's in the favour of the business. I can't remember, but we need to clarify it with the guy's IFA. But the business, would the business be the beneficiary? Is that right? Does that sound plausible, or is that?
We're talking about the life insurance.
Aye.
So life insurance can be, but isn't always by default held on trust.
Right. So relevant. It will be a relevant life policy, if that makes any difference.
It does.
So,
that is definitely in a trust, because to be a relevant life plan, it has to be held in a trust.
Okay. So the point of the relevant life policy was to obviously to pay the value of the guy's shares to the to somebody, to the business or the beneficiaries.
Well, it should be, if it's a relevant life plan, it should just be to his family. It shouldn't be going back into the business.
Right, I can't remember anyway. So but that's in terms of planning for IHT, that's not a bad situation then.
Well, that money from the life insurance goes into a trust, which isn't part of this person's estate for inheritance tax purposes. Okay. So it's not included in the $1.5 million calculation.
Right. All right. Even better. That's fine. I'll let that hypothetical person know that. It'd be very interesting.
Yeah. So it sounds like what this hypothetical person needs to do really is just make the will. Just get on with making the will.
Aye.
Because in case the death of the hypothetical person is literally in the next 12 months, because the youngest is 17 years old, you want to really cover that, because otherwise they'll get a certain entitlement that can't be varied.
Right.
And this hypothetical person, sorry.
No, go on.
I was just going to say, this hypothetical person really needs to be thinking at the same time as the wills, as making these lasting powers of attorney or equivalent in that jurisdiction.
Yeah, makes sense.
Yeah, and the other point that this all brings up as well, for this hypothetical person, is that they've got a business here, and something that I don't know whether you see a lot of this, Raphael, but particularly if it's a limited company where the person who dies is the sole director and a majority shareholder. You can get into all sorts of messy situations with regards to transferring their shares and appointing other directors after the death. Is this something that you've ever dealt with that kind of thing, Raphael?
Yeah, you need to really be clear on the articles of association about who has there's like sort of first refusal to buy the shares, and also again about in the event of capacity of a director, what happens. So
that's absolutely it. Yeah.
So
we've had situations with our clients in the past. I mean, since I don't know how long ago it was that you didn't need to have a company secretary in single director companies. It's been in my sort of career lifetime. I can remember where you had to have a secretary and what have you. But we've had situations where a client will die and be the sole director of the company, and all sorts of entanglements. Do either of you guys have any kind of advice on that? I mean, I appreciate that it's no actually about inheritance tax, but it is about death, so it's still on topic. So if a client, single limited company owner, has probably the majority of the shares, or if not all of the shares, hasn't got a company secretary, there's no co-director, the guy dies, what happens to the management of the company? Clearly there could be a value in it. Again, part of his tax planning could mean that he's got a fair few quid in that business, and then unfortunately he's died. So all sorts of entanglements there. You know, there isn't anybody making any decisions. The bank would be unwilling, I guess, to release any funds and so forth. So what do we do? One, to avoid that, and I suppose if it does come around, what do we do then?
That is literally a situation I was advising on about 6 months ago, because very, very, very similar setup, and it's a real interesting situation because of some of the quirks of the Companies Act. Basically, what happens if a sole director dies and there's nobody to actually run the company? Now, if you've still got some shareholders in there, if it's 5% or more that they still hold of the voting shares, then basically, as long as they can form a quorum under the company's articles, I'll tell you what quorum means in a second, then they can basically request a general meeting and they could vote to appoint a new director to continue running things. Now, that assumes that a quorum is basically you need a minimum number of people in order to be able to hold a valid general meeting under the Companies Act. If you don't have, normally that's 2 under the model articles. Now, if you have standard model articles, but you only have 1 shareholder left with 5% or more, then they're kind of stuck. What you have to do then is you have to apply to court for an order, and that can get really messy and take ages. So some things you could do is obviously have, I mean, these are just general ideas, but you might have a second director appointed so that if one of them dies, the other one can carry on running things. Obviously, you can talk about succession planning within the business, making sure that, you know, there's someone there that if anything happens, that they can take over. They know how to run it. They have access to everything. You can make sure that there's perhaps multiple shareholders so that they can satisfy the Companies Act meeting requirements, or you amend your model articles to say that, you know, perhaps that they only need 1 shareholder, but that doesn't always work for obvious reasons, because is 1 person a meeting? Probably not. But you know, so there's lots of things you can do. I think certainly if you're a sole director and a majority shareholder, then it's always worth looking at your model articles and seeing if you need to amend those to get specific provisions to provide for this particular situation.
So mostly when a company, again, this is isn't hypothetical. So I mean, these are clients that we deal with day in, day out. Normally, when a client will incorporate a company, it will just rip the memo and arts for the Companies House standard stuff. So
model articles.
Just for clarity, then that's not good enough in these circumstances. So this needs to be looked at.
I think so. I think if you've got a sole, I mean, they're supposed to be suitable for. I mean, they're designed to be suitable for small businesses. That's why they made them, so that it's just a plug in and go situation. But they are not always suitable, depending on what setup you've got for your shareholdings, and whether you've got any other co-directors. That they're not always suitable for single director companies.
Okay, excellent. That's pretty helpful. That's
Do you have any points on that, Raphael?
No, you're more of an expert in that field. I'll defer to you.
Okay, so I mean, we're clattering along here at a good pace. There's a lot of information that's been imparted, and we appreciate that. So, can I just press you on the on what can be done? I mean, we hear about trusts and stuff. So on that hypothetical question, so we're talking about a 1.5 million estate. So if that was all cash, no other assets, maybe a house or something, but predominantly cash, no business assets or what have you, what can we do with this 500 grand that would be subject to tax, or as I understand it, outside the spousal transfer, etc., etc.?
Yeah. So if you are going to be doing proper inheritance tax planning, it's just all about time. Time is the main tool to be able to do inheritance tax planning. You can do so much stuff with that. So, you know, if you want to start thinking about gifting, and even though we talked about this hypothetical person's business being able to qualify for business relief, you can also buy assets, buy a portfolio of shares in businesses that qualify for business relief. So these are usually businesses, say, that are listed on the AIM market. And again, you only need to hold these for 2 years. So when people are buying these kind of portfolios, if you're gifting out of your estate, that's 7 years. If you hold business relief assets, that's 2 years. So that's really good for the older kind of client for time frame. And the return on these assets, not great. I don't know. You know, these kind of things might attract like 3, 4, 5% return over the last few years. But that's not why you're buying them. You're buying them because it means
40%, isn't it?
40%, exactly. So I do. There is a risk there, but is it really that risky? I think I saw a pre-question about what the government aims to do about inheritance tax, and the Tories were talking about lots and lots of changes, maybe cutting it, getting rid of it, but that's all out of the question now. So when they were talking about getting rid of like business relief, one of the issues is so many people have bought these portfolios that the whole AIM market is funded by people for these tax relief. So if they start withdrawing that, if you're looking for growth in the economy, it's just going to crash the AIM market. So I think that kind of thing is pretty sturdy. Chris, what do you think? You've been hearing about stuff like that?
Well, to be honest, yes, I agree with that point on the business relief. That if any changes happen, that could hammer those. But when I'm looking at this sort of planning, going back to hypothetical question that you said, Alan, the easiest way to get rid of the tax, number one, is spend it, because you've earned it. That's the quickest, easiest way to get rid. So first point I'd be encouraging people to do is, are you going to enjoy it? If you're not going to enjoy it yourself, is there someone else that you want to enjoy it, that you're going to still be here to see them enjoy it? So we do some calculations, work out, if you want to give a big chunk of your assets away, that cash pot, can you still afford to do everything you want to do? And if you can, trusts are great and form a big part of what I do, but there's a lot of merit just to say, well, it's better to give with a warm hand than a cold heart, isn't it? So you can give something away, bank on living 7 years. Once you get past that 7 years, you've A, saved a big chunk of tax, and B, you've seen the kids or whoever it was enjoy being mortgage free, being happy as Larry, or whatever that is. So there's a lot to be said for the really simple.
It might be worth, just for listeners, whatever we're going to call them, viewers and what have you, just explain what a trust is. You know, I mean, we're all professional people and we work in finance or law and what have you, so we'll have an understanding of trusts. But perhaps the people that are paying attention to this maybe won't. So could somebody give us a 30-second explanation what a trust is?
So a trust is really where someone is gifting money away from themselves. Okay, so taking money out of their own estate and putting it into a mechanism where some people own the legal title and they're called the trustees, and other people have the beneficial interest of those assets and they're called the beneficiaries. It's a way of sort of splitting ownership of assets for certain kind of reasons. So it used to be the case that they were good tax saving vehicles, but that's less now. But what they're really good for is asset protection. So you're basically making sure that the people who can benefit from certain assets don't necessarily have control over those kinds of assets. And there's all kinds of different trusts, but trusts are just like I'm sure Chris will sort of agree. Trusts are just a tool, a mechanism to achieve a later aim. So knowing all about trusts is kind of, you're kind of moving one step ahead of what you want to do.
Yeah, well, conceptually, I like to just, people can get their head around, because trust's a weird word. It sounds quite, you know, litigious and sort of arty-farty. But if you think of your pension, most people have got a pension, which is a pot of money that's got a value, and it's got a load of rules on it. You can only take your money out after a certain age. There's things you can and can't do with it. A trust effectively is the same thing. It's a place where you put your money for different purposes, quite often save a bit of tax, give some certainty as to where the money's going, but it's got rules on it as to who can get money out, when they can get money out. That's, if I really simplify it as much as I can, that's all a trust is. It's just another place that you can put stuff. It's got a different legal owner than you or whoever you're giving the money to. They are a complicated beast, so they're not, it's, you know, a lot of people underestimate the obligations and responsibilities of being a trustee. They are quite severe, so they're great, but they definitely aren't for your average Joe for most things.
They're seen as you know, the mis-selling of trusts could be like quite a big thing coming up on the horizon. So you can use trusts to help with care home fees assessment. So basically what you're trying to do is make sure there's not so much in your estate, so that by the time you're being assessed for care home fees by local authority, they're like, well, you don't actually have that much as you may have done in the past, therefore we're not going to charge you all this money. And that kind of concept has really sort of ballooned, and there's lots of cowboys taking advantage of people having a little bit of knowledge in that area, saying, oh yeah, we can do that trust for you, and getting it completely wrong and not being regulated. And it's just some people are sort of excited by the idea of trusts and how they can save them money, and I just think it's a mis-selling thing coming up on the horizon.
Okay, thank you.
And definitely don't try and set them up yourself. That they can be extraordinarily complex, and there's lots of hoops to jump through legally. Don't try and set up a trust yourself. Always go to someone who knows what they're talking about and get advice before you jump into it. That's you know, something to think about. But just touching on it, you mentioned about, you know, care home fees. Alan, I think we had a pre-submit about that touched on this briefly, didn't we? I don't know whether it's a good time to cover that one. I
was just going to mention. I think you've kind of touched on it already, Raf, giving us a wee bit of information on it, but I'm just going to read I'll read it out, and then we can see if we need to kind of fix it. So, I believe if the home is being given away to the children, the tax limit raises. What happens if the children need to sell the home to pay for medical care, so there is money in the bank rather than the home to sell? Does that then fall into the original lower tax band, or does the allowance stay higher as the funds came from a recently sold property?
So what I'll explain the.
I guess the question
usual
more
way.
would be, what can we do?
Yeah, I'll explain the usual way to deal with, say, care home fees stuff is where you've got a property which is jointly owned by two spouses or two civil partners. Okay. What you want to do is you want to sever the title of the property. So it's no longer owned jointly, but it's owned as tenants in common. So they've both got half each. And then when one dies, they leave their share to the other spouse, but only for life. So the surviving spouse has a life interest in that, but not the capital interest. So when they die, the surviving spouse owns half outright and then a life interest in the remaining half. And on that half, it goes to the children. So if there's care home fees assessment on the surviving spouse, they're only assessed on that half of the house, not this half. So they've got an absolute right to live and enjoy in the income and capital of this half, but only a right of occupation or income in this half. So that's a really, really common way of doing care home fees assessment planning. And the reason it works is because the local authority can't go after the spouse that set that up because they're dead. And that's how it works. That's just my automatic sort of explanation of a care home fees, a common care home fees mitigation strategy. The actual question you read out, I'm not entirely, because I did get it sent earlier. I'll have to have another look at it because it was a bit.
Yeah. So what the question?
I think the kind of overarching question. I'm conscious that we're actually running over time, believe it or not, guys. So I suppose we need to be quick. The kind of overarching question would be is, what can we do to avoid care home fees, basically, as what the question was.
Yeah, I mean, so when I was talking about these sort of cowboys that are doing these trusts and say, well, you can get out of this, that, and the other by handing over the property to the children while the adults are still living there. And they're trying to do that to either avoid care home fees or to avoid inheritance tax. It's not going to work on either. So for inheritance tax, it would be deemed as a gift with reservation of benefit, which means that the parents are gifting it to the children, but they're reserving the benefit of living there. So they're still deemed to own it for inheritance tax purposes. And then for care home fees assessment, if you're trying to get rid of stuff out of your estate, they call that a deliberate deprivation of capital. You're deliberately depriving yourself of capital. So you'd need more information really on this kind of question, because they're saying they're giving the home away to the children. Are they still there? You know, are the parents still living there? Because if they are, that's not going to work.
Right. So, I mean, I guess the kind of the main message, the main advice would be speak to an expert, but speak to an expert before you need to speak to an expert. I think that seems to be the thing, isn't it? That you want to be talking to somebody before your mother or your wife or what have you becomes incapacitated or requires.
Exactly. You know, you can't make a will if you don't have capacity. You know, so it's all about having to think a few steps ahead. Now, people in their 30s and 40s, they can benefit for estate planning, but I'm not expecting a rush through the door for them psychologically. But when people are getting into their 50s, you know, they're mentally thinking about these kinds of issues. And you're right, just speak, because there are things you can do. There's bits and bobs you can do, but you know, when people are talking about transferring the house to the children, I mean, that's just alarm bells, really.
But before we dash, I'm just going to very quickly, because the way I've read this question, I've interpreted it as asking something very slightly different. The answer's quite a quick one. Well, the way I'm reading it is it's saying that the intention was to give the house to the children, therefore benefiting from this extra 175,000 residence nil rate ban that Raf explained at the start of the show. We're calling these shows. But the house couldn't be given to the children because they've had to sell the house to pay for care fees. So this parent is now in care and they've got a pot of money in the bank that's paying for care fees. So the question was, do you now lose that extra
Okay.
allowance that you get for the house or not? And the simple answer to that is, if you've sold the house but kept the money, that you can still benefit from the higher allowance, provided that money goes to the children, but you'll be limited to the amount of money that goes to the children. So if you've got £175,000 allowance, but there's only 50 grand of the cash left, you can only have 50 grand to use as that allowance.
Yeah. So this residence no rate band, it was brought in just to really help people in the south of England who accidentally got rich from house price inflation. So the government made it, there's so many ways to, like you say, there's so many get outs. Even if you've sold the property and you've got cash, you could still use this residence no rate ban. I've got a feeling it's going to be tidied up a bit. I've got a feeling that Labour are probably going to tidy things up a bit, because at the moment, if you don't have children, you don't have property, you lose completely this huge tax band. So I've got a feeling that Labour are going to maybe equal it out a bit.
Well, that was the last question actually that was submitted, and that's probably good timing. So we can probably think about calling it at the halt. But the question was, with Labour now at the helm, are there any plans to change these laws? I mean, Raf, I'm not expecting you to know that necessarily, but what's the
one thing? Yeah, I mean, one thing we do know is that they want to get rid of the non-dom provisions, whereby if you're domiciled abroad, it's not the same as residence. Domicile means where you want to basically be living indefinitely in the future, and certain other qualities are met. You're only taxed on the property that you hold in the UK, not your property abroad. And this is, it's a huge measure to attract, very rich, high net worth, ultra high net worth individuals. Labour say they want to get rid of it. So, watch this space. That's one thing pretty much definitely sure they're going to get rid of that.
There wasn't loads in their manifesto, was there? But I think
no, the Tories did start to very slightly tinker with things just before they got chucked out. Labour have been very coy. They're certainly not going to be cutting, taxes across the board. But for the non-dom thing, if you're a non-dom or you know anyone who's in that kind of situation, I would recommend finding out your position as it stands now, because it's always good to get advice as to how things are now and then how things might change. So that's one thing we can definitely see changing.
Excellent.
Can I squeeze in one last one while you're here? It's good to get this in. I know we've run over slightly, so it'll be a very quick one.
Squeezing it in, then squeezing it out.
Squeeze.
Ever show.
That's great. So Raf, I had a client a few months back who was getting on a little bit, and as part of their business succession strategy, they wanted to gift some of their shares that they owned to one of the senior employees. And we discussed, the legal side of things. And I said, look, there's going to potentially be some tax implications here, possibly IHT. And in the end, they didn't. We worked out a fair market value for them and got them transferred. But in that situation, what would your thoughts be on that? Would there be any alarm bells ringing, and how would the IHT gift provisions kick in if, say, they died in 3 years after that?
Well, so it sounds just like is a typical gift, really, isn't it? So if you're gifting within 7 years, then that reduces this nil rate band that I was talking about, this £325,000 nil rate band. If you're gifting after that 7 years, then there's no effect. But gifting shares in a business, there might be CGT implications there. So like you say, he went to you for advice, or at least to talk about it, and that's really important. And if you're not, this is obviously for everyone, but if you're a professional and you've just got a little bit of information in all these different areas, all you need to know is, oh, that's a red flag, signpost to someone else. I mean, that's the really good thing about professionals who take their job seriously, is they can't fix everything, but they know red flags, and to signpost it on someone who knows what they're talking about.
I think you probably want an accountant involved there as well, depending on the structure of the company. There's potentially, could that be considered a benefit in kind, depending on what role they've got in the business if you're giving them shares?
Yeah,
where
yeah.
shares
There was
are coming from.
Absolutely, there was all sorts of accounting tax issues, which as soon as he suggested it, I sort of thought, okay, well, we're going to need this, 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 and this. But as I said, in the end, it worked out well because we just did a fair market value transfer, so we didn't need to really consider any of these things. But yeah, it was just a really interesting point.
Excellent. Gentlemen, my lunch has arrived.
Yeah, starving
again. Raf, can I go on record and offer my vote of thanks for that? I mean, I'm sure everybody that was listening or watching or whatever we decide is the phrase has learned a lot, because I certainly have been very helpful. So thank you very, very much.
Thanks
Loads
so much.
of useful info. Loads of useful, and that hypothetical person, I'm sure they've got some nice free advice, not advice, sorry, guidance there.
I've really enjoyed it, guys. Really enjoyed it. And
so next week, I think we're back on Thursday. Did we say back to the Thursday slot?
Should be good for it. Yeah.
Yep.
Thursday midday.
Yep. So I'll have to be up early because I'm in New York next week. So I'll be calling in from 7 a.m.
On in around again.
I'll find somewhere suitably glamorous to sit at 7 a.m. Don't have a guest next time, do we? So it'll be
just us.
We'll find out what the topic is, guys, and we'll advertise it or publicise it, whatever we decide, the next couple of days.
Beautiful. All right.
All right.
Been a pleasure.
See you later, guys. All the best.